the guest speaker to you all. Dr. Vivek Yashwant Dhupdale sir is presently the Assistant Professor and HOD at PG Department of Law, Shivaji University, Kolhapur. He has completed BCom, LLB, LLM, NET, and has completed PhD in Law, awarded by the Shivaji University, Kolhapur, under the title of A Legal Study of Intellectual, with a special reference to video piracy in the Indian film industry, and has published a book on same in the year 2019. Honorable Sir has served to many positions named as following: as a junior advocate with Advocate S.S. Rao at Goa for the period of 3 years, two-time as a lecturer and a visiting faculty at different branches of KLE Society, Belgaum, and has also been on a panel of syllabus committee at VTU Belgaum on the subject Constitution of India and Professional Ethics in 2005 and 2006. Again, a visiting faculty of several educational department of Shivaji University, as a senior supervisor for University Exam Center at Humanities for 2 years and at KIT Kolhapur. He has guided more than 500 uh, uh, final year LLM students in their dissertation, Shivaji University Kolhapur, since 2008 till date and continued. He holds a membership at various positions at a different editorial board and has served to many dignified different positions. Honorable Sir has presented 12 research papers at various national and international platforms, participated and attended 27 national and international conferences, published 15 research articles and on various innovative topics at various national and international platforms. He has conducted 17 innovative educational programs and has published several chapters in renowned books. I, on the behalf of whole fraternity of Manikchand Pahade Law College, hardly welcome you, sir. Before we get started, there's a little housekeeping for everyone. You all are requested to kindly mute your audio and video mode so that it could not create hindrance in the ongoing session. If you have any doubt, kindly put it in the chat box of your control panel. It will be answered by the speaker later. Over to you, sir. Please enlighten us all.
Thank you, Ms. Ankita Madam, for the nice introduction. First of all, I would like to congratulate Sri More sir for organizing such a wonderful online lecture series, and thank him for inviting me to deliver this lecture on natural law theories. So I would like to share my PPT now. So is it visible?
Yes, sir.
Okay, sir.
Yes, yes, sir.
So shall I start?
Yes, please.
Okay. Is it visible in the full screen now to all of you?
Yes, sir.
Okay. Okay. So congratulations for this wonderful program. I'm going to deal with natural law theories. So my name is Dr. Vivek Dhupdale. I'm the head of the Department of Law, Shivaji University, Kolhapur. We have this syllabus for our Master of Law course at first and second semester. So initially I used to dislike this subject because it is very tough to clear and to understand also. But when I started teaching this subject, I tell you, I started loving this subject. So today I will do complete justice with this particular subject, the topic which is allotted to me. So let us start. There is a working definition about natural law. It says it is universal, non-man-made, binding, and immutable conditions that govern the consequences of behavior. Natural law is a body of universal spiritual laws which act as the governing dynamics of consciousness. So what do we mean? What is the meaning of natural law and what is the definition now? The actual definition we will see now. So there is no exact definition. Nobody has a complete definition on natural law, but some of the philosophers have tried their level best to define natural law. The term natural law are rules and principles originated from some supreme source other than any political or worldly authority. That means natural law is different from the positive law. Positive law is given by the sovereign, which is man-made. It is a priori method as compared to empirical non-inquiry about causes and reasons for subject matter. It is a physical law of nature based on moral ideals. For example, one of the proponents of natural law, Locke, used natural law as an instrument of change, but Hobbes used it as to maintain status quo in the society. The concept of rule of law in England and India and due process in USA are nothing but they are essentially based on natural law. It is an eternal and unalterable as having existed from the commencement of the world. It is not man-made, it is discovered by the man. It is not made by the man. It is believed that the law is given by the God, the divine. It is not enforced by any external agency. Since it is given by God, we cannot say that, we just say that if you do this particular wrong, God will punish you. But there is no guarantee that God is going to punish actually or not. That cannot be guaranteed. But as far as positive law is concerned, there are rules and regulations which are mentioned exactly if you do particular wrong, you are going to be punished. And that punishment is also mentioned clearly. It is not promulgated by legislation. It is an outcome of preaching of philosophers, prophets, saints, etc. And hence it is a higher form of law. Natural law has no formal written code, no precise penalty for its violation. Natural law has an eternal lasting value which is immutable. Natural law is also termed as divine law, law of the nature, law of God, etc. Divine law means the command of God imposed upon men. Lastly, in modern times, we find it is termed as moral law, as being the expression of the principles of morality. The supporters of natural law argue that the notions of justice, right, or reason have been drawn from the nature of man and the nature of law of nature, and therefore this aspect cannot be completely eliminated from the purview of law. Now let us come to the evolution, growth, and decline of natural law, because natural law is no more a part of a physical or positive law, though some principles have been incorporated in the positive law. But essentially, natural law principles are found in international law. Now, the content of natural law has changed to suit the needs of the time and circumstances. Therefore, the evolution and development of natural law has been through various stages. Now, these stages are number one, ancient period, medieval period, Renaissance period, and modern period. Let us discuss briefly all these stages. As far as ancient period is concerned, Heraclitus, the concept of natural law was developed by Greek philosophers around 4th century BC. Heraclitus was the first Greek philosopher who pointed out at the three main characteristics features of law of nature, namely the destiny, the order, and reason. He stated that is a definition relationship between the things and a defining definite order and rhythm of events. According to him, reason is one of the essential elements of natural law. Socrates, the second proponent, Socrates said that like natural physical law, there is a natural or moral law. Human insight that a man has the capacity to distinguish between good and bad and be able to appreciate the moral values. This human insight is the basis to judge the law. Socrates did not deny the authority of the positive law. According to him, it was rather the appeal of the sight to obey the natural law. And perhaps that was why he preferred to drink poison in obedience of law rather than to run away from the prison. He pleaded for the necessity of natural law for security and stability of the country, which was one of the principal needs of the age at that time. His pupil Plato supported the same theory, but It is in Aristotle that we find the proper and logical elaboration of the theory. Now let us come to the Aristotle. According to him, man is a part of nature in two ways. Firstly, he is the part of the creatures of God, and secondly, he possesses insight and reason by which he can shape his will. By his reason, man can discover the eternal principle of justice. The man's reason being the part of the nature. The law discovered by reason is called natural justice. Positive law should try to incorporate in itself the rules of natural law, but it should be obeyed even if it is devoid of standard principle of natural law. Now, what Aristotle has to say here is that even the positive law has to follow the natural law. It cannot go against the natural law. So he also considered natural law as the highest law, above the positive law. Aristotle suggested that the ideals of natural law have emanated from the human conscience and not from human mind, and therefore they are far more valuable than the positive law, which is an outcome of the human mind. Let us see what the Romans has to say. The Romans carried natural law further to give it a practical shape by transforming their rigid legal system into cosmopolitan living law. They divided the law into three distinct divisions, namely jus civile, jus gentium, and jus naturale. Civil law called the jus civile was applicable only to the Romans, and the law which governed the Roman citizens as well as the foreigners was called as jus gentium. Later, both these were merged together and formed as jus naturale, as Roman citizens was extended to everyone except a few categories of the person. Roman lawyers did not bother themselves with the problem of conflict between positive and natural law, though there was a general feeling that the natural law, being based on reason and conscience, was support the superior positive law, and therefore, in case of conflict between the two, the latter should be disregarded. So again, natural law was held higher. Let us come to the Indian position as far as natural law is concerned. Hindu legal system is perhaps the most ancient legal system of the world. They developed a very logical and comprehensive body of law at very earlier time. A sense of justice pervades the whole body of law. But the frequent change in the political system and government and numerous foreign invasions, one after another, prevented its systematic and natural growth. Under the foreign rule, no proper attention could be paid to the study of this legal system. Mind you, Indian legal system is very, very, very important and very, very simple and effective, but it could not get its development. Why? Because of the foreign invasion. We had Mughals, we had Aryans, we had British people, we had so many European countries invading India. So they had their own laws impressed upon us. Therefore, we lost the touch of our own legal system. There was no investigation, no proper investigation. Now we can see some of the developments which are taking place to study the ancient Indian law. Now, law in India is given in Shruti and Smriti. The king is simply to execute that law, and he himself was bound by it. If he goes against the law, he should be disobeyed. That means the rule in India was even if king goes against the law, he was actually he was not obeyed. He was actually dethroned, or there was a very very dangerous punishment. He used to be beheaded when they went against the established law. Let us come to the next period, that is medieval period. Catholic philosophers and theologians of the Middle Ages gave a new theory of natural law. Though they too gave it theological basis, they departed from the orthodoxy of early Christian fathers. Their views are more logical and systematic. Natural law is a part of divine law. It is that part which reveals itself in natural reason. Thomas Aquinas' views may be taken as representative of the new theory. His views about society are similar to that of Aristotle. Social organization and state are natural phenomena. He defined law as an ordinance of reason for the common good made by him who has the care of the community and community. St. Thomas Aquinas gave a fourfold classification of laws, namely law of God or eternal law, natural law which is revealed through reason, third is the divine law or the law of scriptures, and fourth, human laws, which we now call as positive law. Like his predecessors, St. Thomas Aquinas agreed that natural law emanates from reason and is applied by human beings to govern their affairs and relations. This human law or positive law, therefore, must remain within the limits of that of which it is a part. It means that positive law must conform to the law of scriptures. Positive law is valid only to the extent to which it is compatible with natural law and therefore in conformity with eternal. So even Thomas Aquinas believed that positive law must confine itself with natural law. It cannot go beyond that. He regarded church as the authority to interpret divine law. Therefore, it has the authority, that is, the church has the authority to give verdict upon the goodness of positive law also. So everything was controlled by the church. Thomas justified possession of individual property, which was considered sinful earlier by the earlier Christian fathers. Let us come to the next period, the period of Renaissance. The period of Renaissance in the history of development of natural law may also be called the modern classical era, which is marked by rationalism and emergence of new ideas in different fields of knowledge. Now here you can see in this particular picture, this is called a period of Renaissance. Now what is Renaissance? Renaissance is nothing but when the humans realize that there is a value for their own creations and their creations have to be disclosed to others. And everything was based on the reason, rationalism, which is uh, absent in some of the parts of India. We still believe in blind faith, superstition. Renaissance is nothing but it is away from the superstition. It was that period was based on rationalism. Everything had a reason. Even today, we also have a provision in Constitution of India. We must have a scientific temper. It is our duty. What is scientific temper? Scientific temper is nothing but we should we should believe that if anything is happening, there is a reason behind it. It is not because of some kind of bad luck or something like that. Our Indians have sacrificed to, to destroy or to diminish or to eliminate the blind belief and superstition. We have already seen so many examples. So Renaissance period is nothing but it's a period of discovery, invention, and that's how we started reasoning for a certain thing. Okay, let us come to the proponents of the period of Renaissance about natural law. Hugo Grotius. Grotius built his legal theory on social contract. His view, in brief, is that political society rests on a social contract. It is the duty of the sovereign to safeguard the citizens because the former was given the power to do so. The sovereign is bound by natural law. The law of nature is discoverable by man's reason. He departed from St. Thomas Aquinas' scholastic concept of natural law and reason, but on a right reason, that is self-supporting reason of man. Now the question may arise, should disobey the ruler who did not act in conformity with the principles of Africa? Grotius believed that, howsoever bad a ruler may be, it is the duty of the subjects to obey him. Now, this belief was very, very dangerous because this gave a rise to the dictators and tyrants like Adolf Hitler, etc. So he has no right to repudiate the agreement to take away the power. It appears that Grotius' main concern was stability of political order and maintenance of international peace, which was the need of the hour. Grotius is rightly considered as the founder of the modern international law, as he deduced a number of principles and paved way for further growth of international. So his theory was positively taken. He supported international law. Thomas Hobbes. According to Hobbes, prior to social contract, man lived in chaotic conditions of constant fear. The life in the state of nature was solitary, poor, nasty, brutish, and short. Therefore, in order to secure self-protection and avoid misery and pain, men voluntarily entered into contract and surrendered their freedom to some mightiest authority that could protect their lives and property. Therefore, Hobbes was a supporter of the absolute power of the ruler, and subjects had no right against the sovereign. Though he makes the suggestion that the sovereign should be bound by natural law, it is not more than a moral obligation. So even he believed that there should be an absolute authority, and the subjects are supposed to support and follow him. It would thus be seen that Hobbes used natural law theory to support absolute authority of the sovereign. He advocated for an established order during the Civil War in Britain. His theory came to support the monarch. In fact, it stood for stable and secure government, individualism, materialism, egalitarianism, and absolutism all are interwoven in the theory of Hobbes. Now let us come to the John Locke. According to Locke, the state of nature was a golden age, only the property was insecure. It was for the purpose of protection of property that entered into the men entered into the social contract. Man under this contract did not surrender all his rights, but only a part of them, namely to maintain law, order, and to enforce the law of nature. His natural rights as the rights to life, liberty, and property he retained with himself. The purpose of government and law is to uphold the protection and protect the natural rights of the citizens. So long as the government fulfills this purpose, the laws given by it are valid and binding. But when it ceases to do that, its laws have no validity, no meaning, and the government may be overthrown. Locke pleaded for a constitutionally limited government. The 19th century doctrine of laissez-faire was the result of individuals' freedom in matter relating to economic activity, which found its support in Locke's theory. Unlike Hobbes, supported state authority, Locke appealed or pleaded for the individual liberty. As far as John Rousseau is concerned, Rousseau pointed out that social contract is not a historical fact as contemplated by Hobbes and Locke, but it is merely a hypothetical conception. Prior to the so-called social contract, the life was happy and there was equality among men. People united to preserve their rights of freedom and equality, and for this purpose they surrendered their rights not as a single individual that is sovereign, but to the sovereign, but to the community as a whole, which Rousseau named as general will. Therefore, it is the duty of every individual to obey the general will, because in doing so, he directly obeys his own will. So he says that it is not that individual is important, but as a community as a whole, they should be obeying the laws. Once you obey the law as a community, automatically an individual can be saved or can be protected. The existence of the state is for the protection of freedom and equality. The state and the laws made by it both are subject to general will, and if the government and laws do not conform to general will, they will be discarded. That is what Rousseau has to say. Rousseau favored people's sovereignty. His natural law theory is confined to the freedom and equality of the individual. For him, state, law, sovereignty, general will, etc., are interchangeable terms. As far as Kant is concerned, the natural law philosophy and doctrine of social contract was further supported by Kant and Fichte in the 18th century. They emphasized that the basis of social contract was reason and it was not a historical fact. Kant drew a distinction between natural rights and acquired rights and recognized only the former, which were necessary for the freedom of individuals. He favored separation of powers and pointed out that functions of the state should be to protect the law. He propounded his famous theory of categorical imperative in his classic work entitled Critique of Pure Reason. Kant's theory of categorical imperative was derived from Rousseau's theory of general will. It embodies two principles. Categorical imperative expects a man to act in such a way that he is guided by dictates of his own conscience. Therefore, it is nothing more than a human right of self-determination. Secondly, the second principle expounded by Kant was the doctrine of and autonomy of the will, which means an act emanating from reason, but it does not mean the freedom to do as one pleases. In a sense, Kant held that an action is right only if it coexists with each and every man's free will, according to the universal law. This is called as principle of innate right. The sole function of the state, according to him, is to secure observance of law. Let us come to the modern period. 19th century hostility towards natural law. The natural law theory received a setback in wake of 19th century pragmatism. The profounder of analytical positivism, notably Bentham and Austin, rejected natural law on the ground that it was ambiguous and misleading. The doctrine propagated by Austin and Bentham completely divorced morality from the law. In the 19th century, the popularity of natural law theory suffered a decline. The natural law theories reflected more or less the great social, economic, and political changes which had taken place in Europe. The reason, or rationalism, was the spirit of 18th century thought. Reaction against this abstract thought was over. The problem created by the new changes and individuals gave way to the collectivist outlook. Modern skepticism preached that there is no absolute and unchangeable principle. Prior methods of natural law philosophy were unacceptable in the emerging age of science. The historical researchers concluded that social contract was myth. All these developments shattered the very foundation of the natural law theory in 19th century. His historical and analytical approach to the study of law were more realistic and attractive jurists. They heralded a new era in the field of legal thought. In this changed climate of thought, it became difficult for the natural law theorists to survive. Therefore, those solidarity voices asserting the superiority of natural law are still heard. The 19th century was in general hostile to the natural law theories. So finally, the natural law theories got discarded in 19th century. Okay, towards the end of 19th century, the revival of natural law theories took place. It was due to natural law principles were again accepted towards after the 19th century. It was due to many reasons. First, a reaction against 19th century legal theory, which had exaggerated the importance of positive law, was due to theories which overemphasized positivism, failed to satisfy the aspirations of the people because of their refusal to accept morality and reason as element of law. Secondly, it was realized that abstract thinking or a priori assumption were not completely fertile. Thirdly, the impact of materialism on the society and the changed social political conditions compelled the 20th century legal thinkers to look for some value-oriented ideology. The World War First further shattered the Western society and there was search for a value-conscious legal system. All these factors cumulatively led to revival of natural law theory in its modern or modified form, different from the earlier one. The main exponents of new revival in natural law were Rudolf Stamler, Professor Rawls, Kohler, and others. Now let us see. These are the opponents of modern natural law theories. Rudolf Stamler, John Rawls, and Kaufman Kohler. Let us see what exactly they have to say, each one of them, in brief. Stamler defines law as species of will, others regarding self-authoritative and inviolable. For him, a just law was the highest expression of man's social life and aims at preservation of freedom and individual. According to him, the two fundamental principles necessary for a just law were principle of respect and the principle of community participation. With a view to distinguishing the new revival natural law from the old one, he called the former as natural law with variable content. According to him, law of nature means just law, which harmonizes the purpose in society. The purpose of law is not to protect the will of one, but to unify the purposes of all. According to Rawls, Professor Rawls made significant contribution to the revival of natural law in the 20th century. He propounded two basic principles of justice, namely equality of right to securing generalized wants, including basic liberties, opportunities, power, and minimum means of subsistence, And secondly, social and economic inequalities should be arranged so as to ensure maximum benefit to the community as a whole. Hoffman says, as a neo-Hegelian scholar defined law as the standard of conduct which is in consequence of the inner impulse that urges upon men towards a reasonable form of life, emanates from the core and is forced upon the individual. He says that there is no eternal law and the law shapes itself as the society advances morality and culturally, morally and culturally in course of evolution. He tried to free the 19th century natural law from the rigid and a priori approach and attempted to make it relativistic, adapting itself to the changing market society. So it is the scholar who introduced law and social transformation concept. As the society changes, the law should adapt and keep pace with the society. As far as non-Louis Fuller is concerned, he rejected Christian doctrine of natural law and 17th and 18th century rationalist doctrine of natural law. He did not subscribe to a system of actual values. His principal affinity was with Aristotle. He founded a family resemblance in the various natural law theories, the search for principles of social order. He believed that in all theories of natural law, we assume that the process of moral discovery is a social one and that there is something akin to a celebratory articulation of shared purposes, by which men come to understand better their own ends and to discern more clearly the means for achieving them. To Fuller, the most fundamental tenet of natural law is an affirmation of the role of reason in legal order. H.L.A. Hart, the leader of contemporary positivism, thought critically of Fuller's formulation. He attempted to restate a national law position from a semi-sociological point of view. Hart points out that there are certain substantive rules which are essential if human beings are to live continuously together in close proximity. These simple facts constitute a case of indisputable truth in the doctrines of natural law. Hart places primary emphasis here on an assumption of survival as a principal human goal. We are concerned, he says, with social arrangements for continued existence, not with those of suicide clubs. There are therefore certain rules which any social organization must contain, and it is these facts of human nature which afford the reason for postulating a minimum content of natural law. So John Finnis in his writing Natural Law and Natural Rights, he restated the importance of natural law. For Finnis, natural is the set of principles of practical reasonableness in ordering human life and human community. Drawing on Aristotle and Aquinas, Finnis sets up the proposition that there are certain basic goods for all human beings. The basic principle of natural law are free moral. These basic goods are objective values in the sense that every reasonable person must assent to their value as objects of human striving. So, with this brief discussion of all the stages of natural law, we come to the conclusion. I hope I'm finishing on time. Maybe before that, so we may have some more time for discussion. So, I conclude by saying that natural law has greatly influenced the positive law and has modified it. The law is an instrument not only of social control, but of social progress as well. It must have certain ends. A study of law would not be complete unless it extends to this aspect also. Natural law theories have essentially been the theory regarding the ends of law. The natural law principles have been embodied in legal rules in various legal systems and have become their golden rules. I have to add certain things also after my conclusion. That it is the need of the hour now in the modern world that we should also keep in mind the values of morality, which is nowadays are missing. Now we see so many incidents taking place, not in this COVID-19 period. Some things have come down, or there is a silence because of all those notorious people who were forced to remain in house. So they were troubling their house people, their own home people, rather than troubling on the streets. Some of our lawyers are complaining by saying that the criminals have stopped committing crimes, so we don't have cases to run. That is what they say. Yeah, because of COVID-19. But before that, uh, it's there is a need. There is a need that every individual has to be trained. Now, in near future, we are going to organize one program for all the youths of department. I mean, all the departments of Shivaji University, except the college students. Uh, we are going to teach them the moral values, and we are going to make them realize how society is important for them. And in their day-to-day life, they have to take care of certain things that it may trouble them in their future career. For example, they must know that if even if there is one case registered against their name in any police station, it may cause hindrance for their appointment in any government positions. For example, the IAS, IPS aspirants should take care that they should not indulge in any kind of antisocial activities like creating riots, destruction of the government property. Now, as far as moral values are concerned, these youths, and all of us, we need to be taught how to behave in the society. See, society is for us, and we are one of the members in the society. And as lawyers, we are the leaders of the society. So it is our duty to understand the value of morality in our life. So, though we have seen now the historical part of natural law, some of the proponents of natural law, they supported slavery because they said that slavery is the job. It is your destiny, they used to say. And they supported. Later on, we see the developments saying that human values are more important than the slavery. Slavery is wrong. But again, the slavery was discontinued. In the American system, there was a discussion between one of the resource persons from America. He used to say that people used to speak as if we have a property, just like how we have property. I have land, building. They used to say, I have so many slaves as their property. Now, these kind of aspects have gone past now. We cannot follow them. Now, in India, casteism is one of the worst conditions as far as it is worse than the slavery. That has to be um, completely eliminated from the society. Everyone should be treated equally. So natural law do play a very, very essential role in our life. Natural law principles are there in international law. Therefore, the United Nations organization, they support peace and order around the world. As we, as it is said, that natural law does not have a true sanction behind it. So therefore, it cannot be relied upon 100%. So then we come to the municipal law, the, the positive law. Positive law is also essential. But at the same time, positive law has to be also based on human principles, humanities. So humanity has to be observed. Now, humanity comes from the concept of natural law. So therefore, we have human rights, human values, which have to be kept in mind while doing our own duty. The police, the law enforcement agencies, the courts, everybody has to follow the human principles. And human principle is nothing but it is an offshoot of natural law. So with these few words, and I would like to conclude my session. Thanks to the organizers for inviting me to give this wonderful lecture on natural law. Thank you so much.
Thank you, sir, for such a knowledgeable session. There are few questions dropped by the attendees in the chat box. If you permit, may I please present the same to you?
Yes, yes, please.
As you just mentioned about the morality, human morality, I will pick up the question highlighting the same. So the question asks for that how do we determine the morally praiseworthy traits of human nature? Traditional natural law theory has highlighted the positive traits of humans, such as the desire to know the truth, to choose the good, and to develop as healthy, mature human beings. This question comes to the mind because Thomas Hobbes in his book Leviathan has said that life of human beings was selfish in a state of nature. It was nasty, brutish, and was full of fear. So it is questionable that behavior in accordance with human nature is morally right, or behavior not in accordance with human nature is morally wrong. Suppose if it turns out that human beings, at least the males, are naturally aggressive, should we infer that war and fighting are morally right?
What
May I, may I
what
interrupt
exactly
here?
is the question?
Yes. Mr.
Question
Shukre,
should be precise.
Ravikiran, can you please summarize your question in brief? You please unmute yourself and ask the question to sir.
What exactly you want?
Yes. Ravikiran. बंद करें.
Hello.
Yeah.
Hello, sir. Am I reaching to you?
Yes,
Yes,
yes.
yes, definitely.
So, sir, the question is whether the human trait that has been provided by the natural law theory, which has been highlighted in my question, that is to know the desire to know the truth and etc.
Okay.
Hello.
Yes. Yes, I can hear you.
So,
Please go on.
so it provides that especially human beings are tend towards good, but in his book Thomas Hobbes has said that human beings were nasty, brutish, and very full of fear. The state of nature was full of fear, and
Okay.
the question is, how do we determine the morality regarding this?
See, he had referred as far as his own, I mean, the situation at that time, because humans, and he is not referring to all and each and every person, that everybody was nasty and all those things. So he was referring to a particular situation wherein the human beings can be staying under fear, because in those days there were monarchs, kings, and the subjects had to obey the person who is ruling. So according to them, whatever is the rule, which is one of the natural law, the king has to obey, and whatever king decided, the subjects have to follow, right? And the king has to subject to the natural law. So if king does something a wrong thing, he has to be overthrown, or he has to be removed from his kingdom. So that was the conclusion of the proponent. So what exactly is the question according to you? Is that how to determine the wrong and right by the people? Is it so? Hello?
Yes, sir. Yes, sir.
Yeah, okay. So,
If we refer the natural law theory, then
yeah. You mean to say, is the situation relates to today's modern natural law or the law which was existed at that time? How do you want
today's
the answer?
situation.
Modern, okay. Modern situation, as I say, that there are certain principles that have to be followed by the positive law, even the positive law. That's the reason why we have natural justice being introduced in our legal system. Nobody can be condemned without hurt. Okay, so as far as modern natural law thinkers are concerned, they have revived after the 19th century, they said that even natural principles have to be there, because too much reliance on the positivism may lead to a condition wherein there may be some kind of tyranny or dictatorship. Okay, too much reliance on the man-made law may lead to undermining the moral principles. So to introduce morality in law, natural law theories have to be there, and some kind of natural feeling has to be there in the law, so that human aspect, human values have to be recognized, and therefore we see that law also consists of some part of positive law consists of some part of natural law also. At international law also, you have moral principles which play a very important role. So that is how we can say that natural law theories have to be even following moral principles. I think I have satisfied your question to some extent.
Yes, sir. Yes, sir. Thank you.
Okay, thank you. Thank you for asking the question.
Yes, thank you, sir. The next question is regarding your view. Can we say that John Locke supported the constitutional monarchy?
Yes, I can't say that, because he said, according to him, everything has to be based on the betterment of the society and not individual alone. So yeah. So, and he also said that if the monarch, if the leaders, they don't follow the constitutional principles, they can be dethroned, and some other can become a leader. So Locke's principle was based on the betterment of the community as a whole, not as an individual. So that is what he found it. Yeah.
Thank you, sir, for clearing the doubts and for bringing
Yeah.
the conceptual clarity.
Right.
Now we are
Thank
at the verge of ending this session. I take this opportunity to propose vote of thanks on the behalf of Manikchand Pahade Law College. I express my sincere gratitude towards our guest speaker for today's session, Dr. Vivek Yashwant Dubdale, sir. We are grateful to you for taking your time out and for enriching us with your words, knowledge, and wisdom. We also express our sincere thanks to our respected principal, Dr. C.M. Rao, sir, to our Vice Principal, Professor Sri Kishan More, sir, to our IQAC Coordinator, Dr. A.N. Kotapalle, Madam, and to our faculty in charge, Dr. Amol Chauhan, sir. And at last, I also thank to all the attendees for being cooperative throughout the session. Be there at the same time for the last session of this lecture series, which will be taken by Mr. P. Biola Kiran, Assistant Professor, DSNLU, Vishakhapatnam. Till then.
Thank you so much. Thank you for inviting me.
Thank you, sir.
Yeah, I wish Sri, our Vice Principal of MP Law College, Sri Kishan More, sir, I wish you all the best. And I wish all the participants, including our Honorable Principal, sir, very prosperous and COVID-19 free and vaccinated New Year 2021.
Thank you very much, sir. Same to you.
All the best. All the best.
Now we are going to end the meeting.